Hi everybody, my name is Griffin Bridgers. For those of you who are longtime listeners to this channel, you may have seen the lack of videos lately. I am in the process of upping my game, for lack of a better term, creating more production value, talking head videos, and those take a lot more time to plan out, implement, record, and edit. So I've got some great stuff coming down the pike, and also some conclusions to prior videos and video series that I started and never closed the loop on. But for the time being, today is more of a personal promotional type of idea I've had for a while that I'm starting to implement and test in the market. That's why today's presentation is called After the Ink Dries, Post-Legal Services for High and Ultra-High Net Worth Families. So as I mentioned, while this presentation is not legal or tax advice, it is personal promotion, but it's not intended to be an advertisement for legal services. So as we go through, if anything stands out in here and anything you hear is appealing to you or your practice, you can email me at griffin.bridgers@gmail.com. So what kind of drove this presentation was a question that was recently posed to me by an advisor. I've, obviously changed facts, the question, the text, the circumstance, so on and so forth, but the question was generally, my client just had a comprehensive estate and tax plan implemented by their attorney. However, they now have questions about how everything fits together, and it doesn't make sense to pay the attorney by the hour to review, simplify, and educate the family on their legal documents. What can be done? Well, that's a good question, and there's lots of solutions, but the solutions that are commonly accepted bring up more problems. For one, could the drafting attorney do this? Sure. The advisor in the question hadn't discounted that fact, but there are some issues. Obviously, there's the cost working backwards. You're facing hundreds or thousands in additional legal fees for each question, especially if you've used a higher end attorney. Some other things are, one, the attorney has a biased eye towards their own drafting. It's often said that attorneys have a hard time editing their own documents, and it's hard for attorneys to catch errors. They need that second set of eyes within the firm itself, but obviously you're blinded to hidden issues in anything you draft. So it helps to have that outside second set of eyes, which we'll table for a discussion in a few minutes. The attorney also may lack information about the client's, background or forefront issues, their balance sheet, their income statement, their family dynamics, and their specific needs, especially when compared to any financial advisor and possibly tax preparer. Each person has their own area of knowledge, and often the financial advisor is the one that holds most of the, soft skill type of knowledge. Then, especially now, there's a lack of availability. The attorney has to shift their attention to multiple projects and multiple clients and may lack the time to immediately answer a question or fit in the client for a meeting, much less review everything that the attorney has already drafted. Now, of course, you could engage a different attorney, but you'll run into the exact same problems as set forth above. But the bias will be a little bit different. This time, the attorney is going to bill more to get up to speed, and in doing so, they may do it for free, but with the angle of trying to, from their own biased perspective, sell the client on why the new attorney should tear down and rebuild the plan using their own forms, which I've seen happen even for documents that should be irrevocable, but now you can do all sorts of modifications, decantings, and things like that with trusts. And believe it or not, I have seen attorneys decant trusts just for the sake of using their own new forms. So, is there another solution to find somebody with the legal training to review and simplify the client's situation? And the answer is yes, probably. Could you find an independent attorney who's maybe acting in a non-legal capacity as a wealth strategist, who could deliver this guidance at a negotiated rate without the expectation of drafting additional documents? Well, maybe that's the gap in the market that I've seen and that I am now trying to fill. So the goal would be that the wealth strategist could analyze documents, illustrate how they fit together, and then work with the financial advisor on the numbers behind each of the documents. They could answer client questions that really integrate not just the legal plan, but the personal financial needs and the family needs and dynamics that are unique to that client. And for that, I propose today an illustration of a different balance sheet, because most people think of the balance sheet in terms of an individual or a business, but most families, especially high net worth families, have potentially many different buckets with their own individual balance sheets or accountings, and all of these buckets make up the family's base of wealth. But they have different intended beneficiaries, different intended controllers, and different, use factors that come into play. So if you want to provide the holistic strategy we've discussed, you have to go beyond just the simple review of documents, because any attorney could do that. But one must know what each bucket holds and how the buckets interact. And this is where the financial advisor and maybe an independent attorney as a wealth strategist could work together. Now, once you do that, once you identify the buckets, there are several balance sheets and financial statements you must integrate. So to illustrate here's a quick intro that I've done where maybe the cover sheet or the second page after the table of contents just shows visually what each bucket is and how much it holds. On the individual side, you can have the individuals and estates and revocable trusts, which have up to a certain number, maybe 25 million. In that, you could attach individual financial statements along with any financial statements for revocable trusts that actually have assets funded into them during the client's lifetime. If you have any family entities, those could come in. You could have a family partnership, maybe one family master partnership wrapping everything in. And it could also mean multiple entities, in which case, either case really, you need to know the subsidiary entities and holdings and maybe an updated balance sheet for the combined enterprise or each entity. You could also have previously created gifting trusts, maybe a SLAT, maybe a grantor trust for children, maybe multiple types of trusts like that. So here, I propose maybe that the client had a 2012 SLAT that might have been funded with $5,120,000 back then, and maybe it's now grown to $8 million. And with that, you can attach what you should be receiving every year as a beneficiary, the accounting of that SLAT, or the balance sheet. Similarly, you could have an ILET, irrevocable life insurance trust, or maybe multiple ILETs set up by the family. The death benefit could be within the base of family wealth, and the policy documents and maybe even the current policy value, as may be illustrated on the most recent Form 712, could be attached as well as separate tabs. And then finally, on the charitable side, you may have things like a family foundation, maybe a donor-advised fund, maybe charitable trusts that have been created. That could be its own bucket with its own independent identification of wealth and its own balance sheet and maybe its own tax reporting forms upon which a balance sheet may be reported, such as Form 990 PF. So as we see here in the example of our hypothetical family, we have a wealth base of $77,500,000. Now obviously each of these buckets benefits a different person or maybe even a different charity, and the people creating it can't personally benefit depending on the type of bucket involved. So what are those restrictions? Well, that's where it's difficult to kind of integrate who is the beneficiary and stakeholder under each of those documents or buckets, and how do they interact with the family's overall wealth picture. So in this is a good breakdown because it allows subsequent tabs to show the financial condition of each bucket. So instead of having one consolidated family balance sheet, really you're integrating a lot of different balance sheets and financial statements. And this is a task that can be owned maybe by the financial advisor with the assistance of the strategist. And you may have to round up trustees and other stakeholders and controllers as well. But this is an area where color codes help simplify things. You can use a universal color color coding to help the client over time, such as gray for individual, orange for entities, light blue for gifted assets, dark blue for life insurance, and yellow for charitable. Now those just happen to be theme colors at the top of PowerPoint, which is why I picked them. There's no significance to the colors, but nonetheless, that color coding is an added hidden benefit. Also, you could have supplemental information integrated into the balance sheet or even into the wealth plan itself to show how each bucket interacts with the stakeholders, whether they're individual family members or charities or even other buckets themselves. And this is a task that could be owned by the strategist, maybe with assistance from the financial advisor to kick in the relevant financial information, family dynamics, and other things that should be known to all parties working as a collective. And where legal work is involved, your client would retain outside counsel, obviously, for the various buckets, but each color code could also correspond to a different attorney as well. So, as this is shared among the client's attorneys, if they have multiple, each attorney knows where their tasks fall into the overall plan. So, where does this leave the estate planning attorney? Well, traditionally, this is something that's going to have to be rethought, because this is the issue I've long had with my own practice, is that most estate planners are compensated and incentivized on evergreen estate planning opportunities. In other words, unless a document is being drafted, there's often no way to involve an estate planner and or compensate them for their time. So, because of that, you typically have an estate planner playing a transactional role that, they may draft a document, have the client sign it, then maybe there's some follow-up involving funding and transfer tax returns. But typically the estate planner's role ends when the ink dries on the legal document creating each bucket, and subsequent estate planner involvement requires additional transactions, in other words, additional updates to the documents. So, the strategist, as I've proposed in this presentation, fills the gap to review, simplify, and educate the client's overall legal and financial plan in assistance with the financial advisor once the ink dries, which is, ironically, my new slogan, Griffin Bridgers, for after the ink dries. Review, simplification, and education for a client. So, this is an approach which may be the model for many high net worth families and maybe even the mass affluent market going forward. Now, all parties have a gap in knowledge. You've got tax, you've got legal, you've got financial, and I haven't left out tax, intentionally. I've only included the fact that a lot of financial advisors have found ways to at least integrate some of the individual tax filings into their practice. But not ignoring you CPAs, you still have a role in this process as well. But everybody has a gap in knowledge. Financial advisors have a gap in knowledge and expertise, especially on the legal side. No matter how much you learn, a paraplanner, associate advisor, and service specialist isn't going to know enough to match an attorney's expertise when it comes to the legal and tax issues. And drafting attorneys have a gap in knowledge and expertise as well. They only find out just enough to do the job because they're usually brought in by the financial advisor, and the attorney may not discover or know the background issues and dynamics that affect the documents, even if those are relevant to the family's picture. And there's a number of services out there that seek to do this now with a quote-unquote estate planning review, but these services can't handle the complex. They rely on really commoditization in order to scale and automate the process, and then punt the burden of the presentation to the advisor, who once again has that gap in knowledge that might keep them from effectively presenting that estate plan review. Which, to conclude, is where I come in. If any of this resonates with you, or if you'd like to discuss this more either for yourself or even as a model you'd like to take on, I'd love to work with you. Email me at griffin.bridgers@gmail.com. Thank you for listening. Watch for more refined content coming down the pike education-wise, and I look forward to seeing you in that future content.